7, the Ensuring Accountability and Agency Rulemaking Act for the purposes of markup, and move that the committee report it favorably to the House. The clerk will report the resolution.
H.R. 357 to require the head of an agency.
Without objection, the resolution will be considered as read and open for amendment at any the bill will be reported as read and open for amendment at any point. The chair recognizes the gentleman from Virginia, Mr. Klein, for an opening statement on the bill.
Thank you, Mr. Chairman. I'll be brief. This is in keeping with today's theme of reining in excessive executive branch bureaucracy and restoring accountability to the Article 2 branch. Our framers understood that to ensure an effective government, the executive branch should be armed with the constitutional duty to execute the laws, but not to make the laws. So these powers over the course of time have been abused and expanded through the appointments clause of the Constitution. All agency heads and principal officers are appointed by the President and confirmed by the Senate. Inferior officers must undergo the same appointment process unless Congress by law has said otherwise. And the court has consistently agreed that rulemaking is a significant government power that may be exercised only by officers appointed in accordance with the Constitution's appointments clause. Buckley v. Vallejo in the Supreme Court supported the conclusion that only principal agency officers like department heads and assistant secretaries confirmed by the Senate may issue regulations that have the force of law and cannot be amended without any other rulemaking procedure. But compliance with constitutional rulemaking requirements has been inconsistent. This undermines accountability and opens agencies up to legal challenges because of improperly issued rules, which also provides uncertainty for individuals and business owners and for those on the other side who like the issuance of so many rules. To insert doubt into that process is something they should be concerned with as well. According to a 2017 study by the Pacific Legal Foundation, the Department of Health and Human Services rulemaking practices over the last 20 years revealed that of 3,000 rules issued by the agency, approximately 77% were unconstitutionally issued without principal agency officer approval. Of FDA administration final rules, 98% were invalid. So this legislation would require that all rules be signed and issued by an individual appointed by the President and confirmed by the Senate. It's a bipartisan legislation supported by members of both parties. Agency rules have the power of law, so it makes sense that the legislative branch has some say in who's behind them. And I urge support for the legislation, and I yield back.
The gentleman yields back. We now recognize the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the Ensuring Accountability and Agency Rulemaking Act is a misguided proposal that would ensure that the process of confirming nominees to administrative agencies is even more politicized and onerous than it is today, while also blocking the regular work of our executive branch agencies. This bill would require any agency rule made under the Administrative Procedure Act to be issued and signed by someone who is appointed to their position by the President, and confirmed by the Senate. This requirement on its face may seem innocuous, but it provides Congress the weapon it can wield to prevent the ongoing work of agencies by blocking a president's nominations and leaving an agency without an eligible person to issue regulations. In the past few decades, the process for Senate confirmation has lengthened considerably. Although we have passed measures like the Federal Vacancies Reform Act to ease this burden, there are still over 1,000 executive branch roles that require Senate confirmation, and far too many go unfilled for years at a time as it is. By requiring that rulemaking must be initiated and signed by a Senate-confirmed leader, this bill would add more politicization to the confirmation process and could give individual senators more incentive to block nominations for the sake of a partisan goal. This would add unnecessary delay in the creation, promulgation, and implementation of critical new rules that serve to protect the public's health, safety, and security. The bill's sloppy drafting also adds ambiguity to the process. For example, the bill requires that any rule must be initiated by a senior appointee. But what action qualifies as initiating a rule? Is it when it is first posited in a meeting at the agency? Is it when staff start drafting a notice of proposed rulemaking? Is it when a proposed rule is put out for notice and comment? Is it something in between? We do not know. Instead of creating another obstacle to agency rulemaking, I urge my colleagues to join me in supporting constructive measures like the Stop Corporate Capture Act by Representative Jayapal, which would make agencies more accountable to the public and not just give the Senate another reason to delay a nominee or even to allow a nomination to lapse. I urge members to join me in opposing this bill, and I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the gentleman from Virginia to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 357, offered by Mr. Klein of Virginia.
Without objection, the amendment will be considered as read. The chair now recognizes the gentleman from Virginia to explain his amendment.
Mr. Chairman, this amendment adds the commonly used acronyms OIRA for Office of Information Regulatory Affairs and OMB for Office of Management and Budget in defining the term administrator. Changes clarify the meaning of the bill and make it more easily understood. They're not intended in any way to alter the important purpose of this bill. I urge my support for my amendment, and I yield back.
Yep. All right, without objection, the amendment is agreed to.
Mr. Chairman, for purposes of a unanimous consent request.
Okay.
Mr. Chairman, I ask unanimous consent that a letter from the American Federation of Government Employees and a letter from the Coalition for Sensible Safeguards be admitted into the record.
Without objection. Who seeks recognition? Gentlelady from Pennsylvania.
Mr. Chair, I have an amendment at the desk.
Clerk will report. Gentleman from Louisiana reserves point of order.
Amendment to the amendment in the nature of a substitute to H.R. 357, offered by Ms. Scanlon.
Without objection, the amendment will be considered as read. Gentlewoman is recognized.
Thank you. Just like the REINS Act, which we just completed consideration on, this bill is another disguised attempt to gum up the rulemaking process for the entire federal government. This does nothing to provide more congressional oversight over the rulemaking process. It just creates another bottleneck that our colleagues across the aisle can take advantage of to stop rules they don't like. My amendment is a straightforward fix to undo the harms this bill would create. The addition I'm proposing would allow interim heads of executive branch agencies to approve final rules, so long as the president has nominated a successor. And I view this as a really necessary improvement to this bill because we have all too recently seen what happens when the Senate employs disingenuous tactics to refuse to confirm a duly nominated appointee by the President of the United States. So this is a common sense policy to ensure that politics doesn't jam up the ability of our federal agencies to function properly, even if the Senate cannot. I yield back.
Gentlelady yields back. I withdraw the point of order. Who seeks recognition? Mr. Klein is recognized for 5 minutes.
Thank you, Mr. Chairman. I would urge my colleagues to vote against the amendment. The amendment really defeats the purpose of the bill, which is to restore some accountability to the people in the issuance of these regulations by ensuring that someone appointed by the president on an interim basis and not confirmed by the Senate can sign off on regulations. You're really not changing the status quo, and I think we would all agree that the status quo is broken when it comes to the actions of our bureaucracy and the issuance of these thousands of pages of regulations each year. So I would urge my colleagues to defeat the amendment, and I yield back.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment by the gentlelady from Pennsylvania. Clerk.
Aye.
All in favor say aye.
Aye.
Thank you.
Aye.
All opposed? No. Independent chair, the noes have it. Roll call is requested. The clerk will call the roll.
Mr. Jordan? Mr. Issa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparks? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Ms. Bush votes aye. Mr. Ivy? Mr. Ivy votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Schiff, you're not recorded. Mr. Schiff votes aye. Ms. Sparts, you're not recorded. Ms. Sparts votes no. Mr. Gates votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Chairman, there are 8 ayes and 17 noes.
Who seeks recognition? Question occurs on the amendment in the nature of a substitute offered by the gentleman from Virginia. All those in favor will say aye. Aye.
Aye.
Those opposed, no. Opinion of the chair is the ayes have it. The question now occurs on final passage of the bill as amended. Those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it.
Recorded vote, please.
Recorded vote being requested. Clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Gooden?
You won.
Mr. Van Drew?
You did it right.
Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes yes.
Okay, then I'll keep.
Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Schiff? Mr. Schiff votes no. Mr. Cicilline? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Ms. Bush votes no. Mr. Ivy?
No.
Mr. Ivy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes aye.
Clerk will report.
Mr. Chairman, there are 17 ayes and 9 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 1505, the No Stolen Trademarks Honored in America Act of 2023, for purposes of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1505 to modify the prohibition on recognition by United States courts of certain rights relating to certain marks.
Without
trade
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. In bringing H.R. 1504, the No Stolen Trademarks Honored in America Act, for consideration, the fact is that I want to first of all thank Representative Wasserman Schultz for being the principal co-sponsor on this. The fact is the legislation is intended to right wrongs dating all the way back to the communist takeover of Cuba. The reality is this legislation would prohibit executive agencies from recognizing, enforcing, or otherwise validating any assertion of rights by an individual or a trademark that was used in connection with a business or assets that were confiscated by the Cuban regime, unless original owner of the trademark expressly consented to the transfer of the mark. As we sit here today, there were many famous marks that were seized. The Coca-Cola facility in Cuba was seized, and yet Coca-Cola retains its mark everywhere in the world except, of course, in Cuba. This legislation, in righting the wrong in one circumstance in particular, it corrects a historic wrong and clearly has been acknowledged by anyone who inherently understands the value of intellectual property and the ownership thereof. The legislation makes technical corrections to our law, but one that ensures that protections of our laws apply to all parties claiming U.S. rights to confiscated Cuban trademarks, regardless of their nationality. H.R. 1505 protects U.S. trademarks and their legitimate owners from the effects of confiscation by Cuba or by the Cuban government, and upholds firmly established principles in our law and public policy that foreign confiscation measures must never be given an effect of property transfer here in the United States. And with that, Mr. Chairman, I thank you and yield back.
The gentleman yields back. The chair now recognizes the ranking member, Mr. Nader, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 1505, the No Stolen Trademarks Honored in America Act, involves a long-running dispute over the rightful ownership of one specific trademark, Havana Club Rum. It is a case with more twists and turns than a John Grisham novel. But this bill also stands for an important principle, that we stand with the Cuban people whose property was seized by the Castro regime, and we will not give the protection and benefits of the U.S. trademark system to the holders of stolen property. The Havana Club case begins with the Arechabala family, who began making rum in Cuba under the name Havana Club in 1934, and who secured a trademark from the U.S. Patent and Trademark Office. On New Year's Day, 1960, not long after Fidel Castro had taken power in Cuba, soldiers arrived at the Havana Club office and seized the company by force, and the family was forced to flee to the United States. Unfortunately, for a variety of reasons, the Arechabalas failed to renew their trademark for Havana Club when it expired in 1973, enabling a state-owned Cuban company called Cuba Export, which had been selling rum internationally under the name Havana Club, to swoop in a few years later and to obtain the trademark registration for itself. Although by that time the U.S. had imposed an economic embargo on Cuba, the trademark registration could be held in case one day the embargo was lifted. The story only gets more complicated, however. In 1993, Cuba Export entered into a joint venture with a French company, Pernod Ricard, to become equal partners in their version of Havana Club, while a year later, the liquor company Bacardi paid the Archibald family for their secret recipe and for whatever rights they retained in the original Havana Club. Bacardi began selling its product in the United States, filing for its own trademark in 1994. These dueling trademarks sparked nearly 2 decades of litigation that continues to this day in various forms. But the story does not end there. In 1998, in the midst of the legal battle over Havana Club, Congress included a provision in that year's Omnibus Appropriations Bill. Section 211, as it is known, prohibits U.S. courts from recognizing, enforcing, or otherwise validating any assertion of rights by a Cuban national of trademarks used in connection with any business that was confiscated by the Cuban government. This provision placed the U.S. firmly on record in support of the rightful owners of stolen property and against the use of its trademark system to protect the holders of confiscated assets. Unfortunately, the World Trade Organization later determined that Section 211 runs afoul of certain international obligations because it treats Cuban nationals differently from those of other countries. The U.S. remains in noncompliance with the WTO's ruling today, although Section 211 continues to be valid law in the United States. There is one final wrinkle to the story. In 2006, Cuba Export and its joint venture sought to renew its trademark registration in Havana Club. But because of the U.S. embargo against Cuba, it was not able to obtain the required license from the U.S. Treasury Department's Office of Foreign Assets Control, or OFAC, which would have permitted it to pay the renewal fee. The application remained pending until 2016, when, following the Obama administration's easing of economic restrictions against Cuba, OFAC reversed course and approved the license to pay the renewal fee. At that point, the U.S. Patent and Trademark Office determined that by law, it was required to renew Cuba Export's trademark registration. This finally brings us to the legislation before us today. H.R. 1505 would expand the application of Section 211 to the executive branch, such that in addition to prohibiting enforcement in the courts of a mark associated with confiscated Cuban assets, it would also prohibit any entity of the executive branch from doing so. This would have the effect of preventing the USPTO from renewing Cuba Export's trademark registration when it next expires in 2026, thereby ensuring that the United States protects the rights and interests of entrepreneurs whose assets were confiscated by the Cuban regime unless clear consent was granted by the trademark's original owner. The bill would also remedy the WTO ruling against Section 211 by removing the limitation that it applies only to Cuban nationals. Mr. Chairman, the Havana Club dispute makes for a fascinating tale, to be sure, but this legislation is really about a larger principle. Our trademark system must not be allowed to be a vehicle for the perpetrators of stolen property to profit from their theft. I want to thank the gentleman from California, Mr. Issa, and the gentlewoman from Florida, Ms. Wasserman Schultz, for bringing this legislation forward, and I urge all members to support it. Thank you, Mr. Chairman. I yield back the balance of my time.
The gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from California, Mr. Issa, for the purpose of offering an amendment in the nature of a substitute.
Chairman, I have an amendment at the desk.
Clerk will report.
Amendment in the nature of a substitute to H.R. 1505, offered by Mr. Issa of California. Strike all after the enacting.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of amendment. The chair recognizes the gentleman from California to explain the amendment.
Chairman, I'll be brief. This is simply technical and conforming changes and no other substantive change in the bill. Yield back.
Gentleman yields back. Who seeks recognition? The question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor, aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. We have 4 technical correction bills to be considered. Without objection, the committee will consider these 4 bills in block. Hearing none and pursuant to notice, I call up H.R. 3571, H.R. 3506, H.R. 3496, and H.R. 3578 for purpose of markup, and move that the committee report these bills favorably to the House. The clerk will report the bills.
H.R. 3571, H.R. 3506, H.R. 3496, H.R. 3578.
Without objection, the bills will be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. These 4 bills were submitted to the committee by the Office of Law Revision Counsel. The OLRC is a small office in the House of Representatives that is responsible for preparing and publishing the United States Code. As Congress passes laws, the code needs to be updated to incorporate these new laws and to ensure that references are correct. Providing for the maintenance of the code is the responsibility of the Judiciary Committee, and we work with the OLRC to accomplish that fundamental task. The bills before us today make technical corrections to update internal references throughout the code. These updates are necessary to help Americans understand what our code says. They do not change the meaning. It's important they do not change the meaning or affect any law on the books today. Our committee has historically dealt with these bills in a bipartisan manner, and that will continue this Congress. I want to thank Ms. Hageman, Mr. Kiley, Ms. Dean, and Mr. Ivey for introducing these 4 bills before us today. I urge all members to support the bills. The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, one of the important responsibilities the House gives this committee is to oversee the revision and codification of the statutes of the United States. Keeping track of the new laws Congress passes every session is a formidable challenge, but it is an essential part of maintaining the rule of law in our country, and it is a duty we take seriously on this committee. The body of federal law is so large and complex at this point that it would be almost completely unmanageable without the United States Code. Currently consisting of 54 titles, the Code compiles the general and permanent laws of the United States into coherent subject areas. This makes our federal laws accessible both to the government officials who work to fairly administer them and to the private citizens who seek the benefits or relief the laws provide them. The painstaking and vital work of maintaining and updating the code falls to the expert lawyers working under the supervision of the House in the Office of Law Revision Counsel. We owe a great debt to these attorneys who ably carry out their statutory mandate to develop and keep, quote, to develop and keep current and official and positive codification of the laws of the United States, close quote, while maintaining strict impartiality as to legislative policy. Today, we are taking up 4 editorial reclassification bills that make conforming changes to statutes that have been impacted by the Office of Law Revision Counsel's reorganization efforts while making no change to the meaning or effect of any existing laws. I want to thank the chairman for the bipartisan way in which he is taking up these bills, and I want to thank the sponsors of each bill for their leadership on the important work of this committee. This legislation will help ensure that the code is an authoritative, accurate, and accessible source of federal law, and I urge all members to support it. I yield back the balance of my time.
Gentleman yields back. Without objection, all other opening statements will be included in the record. Gentleman from California is recognized.
Thank you, Mr. Chair. H.R. 3506 makes technical amendments to update statutory references to revisions in Title VII, Title 20, and Title 43 of the U.S. Code. In the process of updating statutory references, related technical errors were found, so the bill also makes amendments to correct those errors. As the chair and ranking member explained, these changes came at the request of the Office of Law Revision Counsel. Thank you, and I yield back.
Gentleman yields back. Gentlelady from Pennsylvania, Ms. Dean.
Thank you, Mr. Chairman, and thank you to the ranking member, Nadler, for holding this markup. I'd like to take just a very brief moment to explain for folks watching at home what we're doing here with this block of bills. Some may be surprised to learn that Congress does in fact pass laws. We pass dozens of laws every session on topics ranging from international treaties to consumer safety standards. Some laws are brand new, others revise existing statutes. Congress has been doing its job for more than 2 centuries. In that time, federal law has grown quite complex. So another one of our responsibilities is to make sure that the laws we have enacted coherently operate with one another and that the U.S. Code makes literal sense. That job is what we're doing here today with these 4 editorial reclassification bills. One of those is a bill I have offered, H.R. 3571. These bills make technical changes like ensuring references between statutes are accurate, that laws are located in the correct section of the code, and that the punctuation makes sense. It is heartening to see that we continue to do this important work, Mr. Chairman, in a bipartisan manner. I thank you, and I yield back.
Gentlelady yields back. Who seeks recognition? Question occurs. Reporting quorum being present, the question is on favorably reporting the 4 bills. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the bills are ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, staff is authorized to make technical and conforming changes. This concludes the committee's business for the meeting. The meeting is adjourned.